So Tommy Robinson's appeal against his sanction for contempt of court failed, but the court has dropped a massive hint as to what he could do to get out early. In fact, it's more than a massive hint, it's pretty much told him what to do to get out early, so I'll discuss that very briefly in this video. I'm not going to go through the whole history of the case in this video because A, I've done that many times before, B, there's a great summary of it by my learned friend Alan Robertshaw from Art of Law, and yes, it rhymes. I'll link that in the description below. Go and check out his video. It's a great summary. It's a great channel. Al puts out great content. Please do subscribe to him as well. But I thought, since I feel massively behind because this was out about 5 days ago and I've been quite severely ill, I'm feeling a lot better now. Thank you all so much for your kind messages. So I thought I'll catch up on a few things. I'll bang a few of these things out and go through this judgment and give you this massive hint, direction really, as to what he could do to get out early. So first of all, if you do like these updates and bits of analysis, please do subscribe. About half of you don't. I'd be really grateful if you did. That helps my channel grow. Let's take a look. So we've got, this is the judgment itself. I'll link these below. And by the way, let me know whether you like this being on a slight angle, this text on screen to my left, your right here, or whether you prefer it flat on. I know some people don't read it. Some people like to read it, but some people like it at a skewed angle. Let me know what you think, aesthetics and all that. So this is, as it says in the highlight portions here, this is the judgment on the Court of Appeal against the sanction for contempt of court. So he was appealing on a number of different grounds, although some of them were abandoned at the hearing, for the punishment for contempt of court. Now, it's not a criminal offence per se, but you are jailed rather than imprisoned, and there's a few technicalities. Again, watch Al's video for a summary of that. But in short, the grounds of appeal are listed here. I've separated them by colour, and some of them overlap quite broadly. So very broadly here, these grounds were that the judge failed to clearly apportion the sentence reduction for onerous detention conditions. The sentence reduction was insufficient given the severity of the detention conditions. The detention conditions are significantly more onerous than they anticipated. Incarceration significantly impacts his mental health beyond the typical expectations. The appellant's recent ADHD diagnosis was unknown at sentencing and may warrant consideration. Insufficient weight given to the civil sentence requiring 50% versus 40% for criminal sanctions, and insufficient weight given to the ineligibility for home detention curfew, etc. So as you'll find if you read that judgment, many of those overlap. Many of those, the court said, well, the original judge either would or would not have known those at the time, and obviously gave them consideration, etc. But ultimately, this failed. But what I'll focus on in this video is the massive hint as to what he could actually do to get out early. And this goes back to October 2024. And this raises the question, even before I go into it, raises the question as to why he hasn't followed this through rather than going through the cost and the time and everything else of going through this appeal against the sanction, but without actually following what was suggested in this judgment. Now, it's quite obvious why I think he hasn't done that yet, and I think he possibly will do that now that this appeal has failed, and that is Al's prediction. I share that prediction. I think this probably will happen now. So let's talk about this. So this is the judgment from October, and by way of summary, there were 10 separate breaches of the injunction, which he admitted doing. It's not that he was, through a full trial and found guilty of contempt. He'd admitted this, and this obviously the publication of the, quote, documentary silenced, etc., and effectively repeating the defamatory statements from the original case, and therefore the court looked at an appropriate sanction. Considered the admissions, considered the time already spent in custody, looked at the minimum sanction for the breaches of this order, and obviously the court saw these as so serious that a non-custodial sanction could not be justified. So a fine would not be good enough, and any other order would not be good enough, and custody was the only sanction that the court thought was justified in this situation. And even before I go on to that main bit for this video, let's talk a little bit about injunctions and what you might do and how you might feel if someone breached an injunction that you'd obtained in court. Al talked about this in his video, so credit to him for the idea, but I've come across this a lot in family courts. In fact, more so in family courts than other things. But once or twice in business cases as well. Business cases might include not releasing confidential information and, not releasing the secret source as it's known. Let's say there's a secret recipe which a company is famous for and nobody knows what it is. And that is why they are successful. That is why they sell their products or food or whatever it might be. If somebody working on the inside knew what those were and threatened to release them, they might go for an emergency injunction to prohibit them from releasing this recipe. And then obviously if they did that, it might cause significant financial damage to the company. If they've released this and other people then copy it, they've lost their USP. And so that is obviously a very serious breach of an injunction of the court. In the family cases, it might be you must not remove the child from school, you must not remove the child from the home, you must not go near the child, you must not do all these sort of things. These are prohibitive steps orders, which is preventing one parent or one party from doing something in relation to the child, etc. We have another type of injunction in the family courts, which is to order somebody to do something. For example, the child lives with one parent and spends time with the other parent. The live with parent is going on holiday, but the other one is retaining the passports. So we call this a specific issues order, whereby this party is ordered by the court to provide the passport to the other parent so that they can go on holiday. It happens the other way around as well. We have the live with parent withholding the passport so that the spend time with parent can't take them on holiday because they've withheld the passport. And this happens more often than you can possibly imagine. I would say almost all of the cases that I ever worked on in the family courts had some element, at the very least, of one parent using one of these tactics, either not delivering up the child for spending time with the other parent, withholding the passport, all these sorts of things, taking the phones away, taking the iPads away. In fact, you'll recall from a video a couple of days ago, I've lost track of what day we're at now, but a few days ago, I did a video where the lady was arrested because there was a false, as it turns out, allegation of theft of the iPads. That is exactly the situation that we have in the family courts, where one parent is accused of stealing something and they've removed the phone or the iPad or whatever from the child. And very often those are provided just to have contact with the child. So they will very often, the court will make the suggestion, well, why don't you provide the child with a phone so that they can have contact with the other parent regularly and so that they feel they've got the connection with both parents. And what invariably happens is the live with parent will take that phone away, or the spend time with parent will take the phone away so that the live with parent is then panicking because they can't contact the child. And this happens, as I say, in almost every case that I worked on, even the very, very, very simplest cases. Now, I worked on everything from parents just can't agree what days they spend with the child, right up to international kidnapping and severe harm done to the child. And I'm talking such severe harm that I won't talk about on YouTube, gut-wrenching harm to the child. And the court was tasked to find out which parent did it. So all of these cases, from the very severe to the very simple, we've had things like this happen. The reason I'm telling you all this is, how would you feel and what would you do if the court has ordered this party, do this or don't do that, and they do it anyway? What would you do and how would you feel? Now, there's rules in place, and that is contempt of court, and the court has the power then to jail somebody if they refuse to comply with that order. In the family courts, it's a long-winded process. You go back to court for enforcement of the order. The court's very reluctant generally to actually jail somebody for breach of one of these, but that does happen. Rarely, but it does happen. Now, what would you do? As I say, I've had clients ring up before now, and the very first phone call has been, we've just walked out of court, and the other party has already said, I have no intention of complying with this order. So what would you do? The order says make the child available to spend time with you on that day, at that time, and no sooner they've walked out of court, they've said, I am not going to comply with this order. So what would you do? Now, coming back to the Tommy Robinson case, this is essentially what happened here. The court ordered Tommy Robinson not to repeat the defamatory allegations, and he did so. And so you are, as Al mentioned, you are free to disagree with the judgment. You are free to say that you disagree with the judgment. You can say, this is what the court found. I disagree with it. I think the court's wrong. You are entitled to say that. What you are not entitled to do is repeat the defamatory allegations as though they are factual and correct. So in that scenario, if you are ordered, let's say if you are ordered not to release a certain information to the public, if you are ordered to stay quiet about something, you're ordered not to repeat the defamatory allegations, you can publicly say, I think that's wrong. I think I should be able to say those things. I think I should be able to do those things. That you're free to say, but do the things that you're ordered not to do? No, you're not allowed to do those. So let's jump in. Just to give you some context, I think it was important to give you all that context so that this sits properly within this video. So let's go straight to how he can get out early. And the court has pretty much spelt this out at paragraph 103. Punitive and coercive elements. The court said it is appropriate to divide the sanction into punitive and coercive elements. Now, if I explain what those mean, it will pretty much become obvious as to what the bit in pink is going to say. The punitive element is the punishment element. Now, we don't have a punitive punishment element for damages per se. We have aggravated damages and stuff like that when we have civil claims, but the punitive element here is the punishment element. The coercive element is to try to get somebody to do something. So if they've done something that they're not supposed to do, let's say I'll use the example of being on somebody's land when you're not supposed to be. So there's a prohibitive injunction to prevent you from trespassing on somebody's land, for example. And if the person, as Al said, you continue to occupy the land because you think you've got a legal right to be there, but the court has ordered you not to be there and you continue being there, the court may then order a sanction to be jailed if you repeatedly breach that injunction, and there may be a coercive element there. The coercive element may persuade you to not continue to breach the injunction. And so there it is. It should be obvious now what the next bit's going to say. The court then spelt out this. The court said the period of 14 months, less 3 days, spent in custody, is the punitive element. That's the punishment element. The balance of the 4 months is the coercive element. That means, and the court literally spelt this out, that means that it is open to the defendant to purge his contempt and seek the remittal of 4 months of the order. In order to do that, he would need to demonstrate a commitment to comply with the injunction. That is likely to require, at the least, the removal of Silenced from his social media accounts and its removal and the removal of other publications that breach the injunction from other online providers, or at least taking all possible steps to secure the removal. And so in short, if he demonstrated a commitment to remove the, quote, documentary Silenced from his social media accounts and took all possible steps to secure the removal from others, then the court may remit 4 months of this order. So that's 4 months just for demonstrating that it will comply with the injunction. And so that is relatively straightforward. But now this appeal has been rejected. Is that now possible? Well, I'd be very, very surprised if the lawyers haven't already said that this is now your remaining option. So I would certainly anticipate that he's been advised to do this and that that is the best course of action now. He could still say, as Al commented, he could still say, I still disagree with it. I still think I'm right. You may all still disagree with it. You may all still think that he's right and the court's wrong, etc. You are open to think that. You are open to say that. But what people are not open to do is to breach an injunction once it's been made. For all the reasons I've discussed in other cases, again, the court makes these orders for reasons. And if someone breaches that injunction, it is essentially disobeying the court and we'd be in a lawless land. So I hope that makes sense. I hope that's useful. I'll link the judgments below. And if you've had a similar situation in the family courts and or any other court in relation to injunctions and things like that, do discuss with your lawyer to challenge them for breach of the injunction and enforcement and even going so far as for a contempt application. One such example I've even had a situation where I've had an order from the court. It's called a third-party debt order. I've had an order from the court to order the bank to pay money over to my client who won in court. So they were the judgment creditor. The bank's client was the judgment debtor. So the bank had money belonging to the judgment debtor. The court, by way of third-party debt order, orders the bank to pay the money to my client. And the bank just didn't do so. The bank, in fact, didn't even reply. Now, to be fair to the bank, I think it just got lost in administrative garbage. Somebody may have left, etc. But the long and short of it is they didn't even respond to all my letters. So the only alternative then was to send them an application for holding the directors of the bank in contempt of court. Sure enough, they paid, I think within about 24 hours, because the directors didn't fancy being jailed for contempt of court, because obviously the directors of the bank were liable for the bank's failure to comply with that order. So I hope you found that interesting. Please do subscribe, like the video, share the video, and I'll see you next time.